Namaste, Sasriyakal, Namaskara, Swagata, Vanakkam, Kemcho, and a very warm welcome, friends. This is Immigration Talk on IndusTV. I'm your host, Usha Changa. As we start the program, I'm hoping you and your loved ones are all safe, and I wish you all nothing but the best of health. Stay safe and stay healthy. US has been that land of opportunity for all of us from India who came here with dreams, right? And we worked on fulfilling them either alone or maybe with your families. These times, these are unprecedented times nobody thought of. These times have created a lot of uncertainty. A lot of uncertainty especially with the non-immigrant visa holders and the whole immigration status. It's become such a confusion. People are trying to understand, and there's a lot of scare as to how, what could be happening there. So today's discussion is going to be focusing on just that. We are going to be working on helping you to understand some of the facts. We have the experts. We have the experts here who have been in immigration business for 20 years. We have attorneys Sheetal Patel and Clement Chang from Pasricha and Patel LLC. So a very warm welcome, Sheetal as well as Clement. Thank you so much for coming over today.
Thank you, Usha. Thanks so much for having us.
Thank you for having us today, Usha.
Yes, and it's really confusing, and that one of the reasons I wanted to have you here is help understand some of these questions that we all have. Is this a myth? We're hearing things. What's a clarification around it, right? We're going to start this session. I'm going to let everybody know. I have attendees attending here. I'm going to let you know. We will start taking your questions. Feel free. There's a chat box. Feel free to put your chat in. I have a few questions that I've gotten already. We'll address those, and we'll definitely come to your questions here. Sheetal and Clement are the experts. They will be able to give you the answers here. So we'll start with the first burning question that all of us have. So we'll go to the first one. How can H-1B workers maintain their legal status during coronavirus pandemic? People have been working reduced hours. They're not being asked to work 40 hours because the companies can't pay. They're probably getting furloughed. They probably need to change jobs or change of address from work office to home. So how can they maintain their legal status?
Okay. Yeah, Usha, that's a very good question. And all of those questions we are receiving probably on a daily basis because of the pandemic and how it's affected the economy and jobs and the market and all of that. So I guess we can break it up because, it depends on the change in hours. If there's, a reduction in hours, for example, there's rules to go by. If the employee is furloughed, there's another set of rules. So, I guess we could start with just reduction in hours. If the employer needs to reduce the hours of an H-1B employee, for example, moving that person from full-time to part-time, that requires a H-1B amendment. So in those situations, an LCA, a labor condition application, does need to be submitted, and then an actual amendment to USCIS must be filed to demonstrate and to inform them that there will be a reduction, in hours for employment for that individual. Now, as soon as the petition is filed, that person can, begin to reduce hours and, maintain his or her status through the H-1B. With respect to being furloughed, that's a little bit different because furlough essentially implies that the employee is going to be placed in some kind of non-productive status. Mm-hmm. And typically the employer has the intention to bring that person, back to employment. For furlough, unfortunately with H-1B, if you're in non-productive status, you have to be paid. So this is a little bit problematic for individuals who are being placed in furlough. And so the question becomes, is there a way to reduce the hours perhaps, rather than if the, employer is unable to make the payments, is that a possibility? So with furlough, like I said, the situation is a little bit different. And then the last thing you mentioned is the work from home situation, which is a very common question that's being raised right now. And, to make it really simple, if the home or the work, if the individual is subject to a work from home due to COVID, and that is an option, you have to look at what the original worksite location was listed on the LCA. And if it is within that geographical region, for example, commuting distance, maybe 10, 20, 30, 40 miles, reasonable commuting distance, then an amendment does not have to be filed. They can simply utilize the original LCA, the labor condition application, which governs the H-1B petition, and the guidelines, provides guidelines for the same. That can be posted, at their home, and that's enough. However, if it's outside of that geographical area, then, we kind of have to, it becomes a little bit complicated. We have to see, is it a short-term placement? If it's short-term, they may possibly qualify for not doing anything and having it be 30 days short-term employment, but anything beyond that, typically an amendment is required. I hope that answered the question.
Yeah. So Clement, I'm going to ask you the next question now. How about changing jobs and change of address? Because now people are not working in the office, they're working from home. Do they need to fill out?
Well, actually, I wanted to clarify something about the furlough before we go on, and that is technically, furloughs are not allowed for H-1B workers at all. If they do, it really is unemployment, and in that situation, what ends up happening is the employee will have to consider filing for change of employer altogether. And so just to clarify, furlough, I know a lot of people talk about that, but that is not an option at all to consider if you want to remain with the same employer.
Okay.
So if that happens and comes up, then you definitely need to consider start looking for a new job, at least to get that change of employer filed with the USCIS. So going back to your question about changing addresses and things like that. Yes, I mean if you're going to be working from home or you're going to be working at a different location, you do need to submit an online change of address application on the USCIS website and update your address with the USCIS, because the rule actually says that any foreign person, unless he or she is a U.S. citizen, must update his or her address with the USCIS anytime they move.
Okay.
That goes for anybody, even for permanent residents, green card holders. So for that purpose, yes, you do need to update the USCIS with a change of address. And as far as working from home, like Sheetal said, depending on where your home address is in relation to what location was submitted on the LCA, you either can keep not do anything and use the same LCA as what you had, or if it's going to be longer than 30 days to maybe 60 days, or if your home is far away from where your LCA work location is, then your employer will have to file an amendment H-1B petition and at least put that petition with the USCIS to let the USCIS know that change is in effect.
That can be a probability, right? Because people may be working in another state Monday through Thursday, coming for the weekend, so.
Sure, that's entirely so. Now, I mean, the thing about filing an amendment is USCIS really just tells the employer to go ahead and file the petition and then just have it process for however long it takes. Right now, it could take for 7-8 months. And certainly during those 7-8 months, things can change again. I mean, certainly with the economy slowly opening up again, it is entirely possible that maybe 2-3 months from now, they're back to their old locations. And if that happens, then the employer is supposed to withdraw that pending amendment petition. And that way, the petition, underlying petition will remain in effect.
Okay.
So in a way, the amendment petition really is just filing for the sake of filing it, so that at least you keep yourself in line with the USCIS guidelines, which were published back in 2015 regarding changing employment terms, that sort of thing. The Semeo Solutions memo.
Right. Thank you for the answers on those. But I think I'm going to move on to something that's absolutely critical, and unfortunately with the economy being, in limbo, people are losing jobs. So when an H-1B loses the job, what happens and what do they need to do? Sheetal, you want to take it?
Yeah, sure. So, yeah, unfortunately, this is a common scenario right now. And, realistically, it can be difficult. Obviously, ideally, the individual is able to find a new employer and file for H-1B, an H-1B transfer. But given everything that's happening, it can be difficult. If the individual holds a valid H-1, meaning when I say valid, I mean with the open validity date of 60 plus days, then they would get and this would be from the previous employer. So from the employer in which they were terminated, if they hold a H-1B approval notice that is at least valid, even though that individual may have been terminated, at least it has a validity date that's valid. They can get up to 60-day grace period. And so that grace period can definitely be helpful to some people in that situation, as it would allow them to, give them a little bit more time to go out and seek employment or find an employer who's willing to sponsor them for H-1B. Unfortunately, the 60 days goes by very quickly. And the other problem, I'm seeing this quite a bit from a lot of our clients, is they find an employer and, unfortunately it takes time, to submit the petition on the employer's part at times. And so it is really important to get the LCA filed in a timely manner, and that takes about 7 days. And then you have, just the filing with USCIS. So it's just one of those things that, the timing case, 60 days, it just feels like it's not enough for many individuals right now, but that is the rule for anybody who holds that kind of approval notice. And unfortunately, if there is no more time left, then it's very difficult right now. And so there's a lot of B2 visitor visa filings, change of status to visitor visa, that is being filed because there are a lot of individuals, for example, from India, who are not able to return to their home country because of the fact that flights are not available. And so for those individuals who really don't have any other options, we are filing B2 change of status, like a short-term visitor visa type of application, to allow them to lawfully remain in the US until they are able to go back and return to their home country.
So a tricky question that I've actually seen happen is the person may get a job maybe day 51 or 52 of the 60-day time that they had. Are they still able to get all the processes, especially in these times? Are they able to get all the processes, all the applications done in that record time?
So it would be tight, I think, to get it if they're, finding that employer on day 52. I think it would definitely be tight to file it within the 60-day period. However, USCIS has offered some guidance in the sense that they're saying if there's circumstances beyond somebody's control, including people who are in a grace period, put that in writing, try to submit the petition and mention what prevented them, from submitting the application on a timely basis. And for somebody who's so close to that 60-day mark, like, day 50, I think it's worth trying, but case by case basis, we would have to see whether it made sense and whether we had enough documentation to be able to demonstrate, that it was out of their control.
Okay, yeah. So, Clement, question for you. With COVID, what's happening with the processing for H-1B new extensions and maybe H-4 EADs? Can you share what's happening now?
Oh, yeah, very interesting questions. The USCIS actually announced, even back in March or so, that because of the COVID pandemic, they were taking extra time to process incoming H-1B petitions that they receive at their service centers. Mostly that affects quota cases, but it is also affecting regular non-capped cases like extensions, transfers, and things like that. We are seeing a lot of cases that get submitted one way or the other, but the receipt noticing, road notices that USCIS sends out, is taking extra time to get issued. So it is quite possible that the petitioner might not receive formal acknowledgement from the USCIS that the case has been properly filed for more than a month. In those situations, we tell our clients that certainly be patient, and do try to keep track of how their filing fee check deposits are made, because what happens is when the USCIS takes the case at the mailroom and they separate the file from the filing fees, when they accept the file, they will deposit the checks, and on the back of the check, they will stamp the case receipt numbers. So keep track of that, at least from the petitioner's point of view. They can check go check with their bank every other few days and see whether the filing fee checks has been deposited or not. And that's a very good indication and of whether the case is received.
Do you sense a delay though? Are you sensing a delay in these?
Yes, we are actually. It's not the delay in the sense that the USCIS is definitely taking longer to issue those receipt notices. Now, the reason they say it's taking longer is precisely because they've instituted precautionary safety measures for the mailroom processing people.
Yeah.
It's understandable that they're in close contact with each other. They're getting all kinds of incoming mail. They have to make sure, certainly, you see what happens with all the various workplace and even shopping centers and meat processing plants. They want to make sure there's enough safety and distance between each worker. So they have to take extra security and safety measures to make sure that they handle the mail correctly. So that ends up taking time for them at the mailroom to open mail, deposit checks, things of such. So that's why it is taking them longer. Plus, actually, especially right now, because the H-1B quota filing season is ongoing, it means also more extra files are being received at the USCIS. So that on top of the regular non-quota cases that are still regularly being filed with the USCIS means more backlog and more work at the service centers and mailrooms. So that's why now, and in fact, like I said before, USCIS had already put out an announcement in March or so saying that, hey, listen, we're just going to need more time to process all the mail. We know it's going to come. Plus, we have to be safe to our, workers at the USCIS. So that's why it's going to take extra time for them to receive and process cases. The actual processing time of the cases, sorry, just to add on to it, it also varies actually. There seems to be some, I'm not sure, we're seeing some trends whereby USCIS adjudication officers themselves are taking rather fast processing times once they actually get the mail files. We think it has probably something to do with the fact that a lot of the cases that happen to be filed right now may be extension cases, with the same employers. So a lot of times it's already approved from before, and perhaps this is a time frame where the USCIS officers are trying to clear a lot of these cases so that they can then turn their attention onto the quota cases, where they'll have to spend more time reviewing those. So I think, again, this is based on what we see in our office, is that we're seeing a lot more approvals come through for extension cases, sometimes even change of employer transfer cases too, but mostly extension.
Amendments as well. Sometimes the amendments are coming back very quickly.
Nice, that's good. We have a lot of questions coming up here, and everybody that's listening, welcome. If you just joined, you're listening to Immigration Talk on IndusTV. We are talking to attorneys Sheetal Patel and Clement Chang from Pasricha and Patel LLC. So I'm going to go to the first question. I do have a lot more questions here, but we'll try to cover what we can. And you guys are going to be in big demand here to get these questions answered. Let's go to the first one by Satish Vaishnav. I want to know how to renew the immigrant visa category. I think you can probably check in your Q&A as well in your Zoom. If my wife, he's talking about categories F42 and F43. If his wife and son were unable to enter US before the 3rd May deadline due to the closure of flights, he has entered USA on 16th of Feb and he's a primary applicant in F41 category.
That's probably that's a brother sister of U.S. citizen and dependent family members.
Okay.
Right. So I think just to clarify, the question is trying to see whether they can perhaps extend their visa validity, because a lot of times, well, actually all the time, the immigrant visas that are issued to family members usually are valid from 5 to 6 months. And it is entirely possible that they cannot come to the United States within this 5 to 6 month period.
Right.
Especially right now, where there's travel restrictions from India and even from abroad in general. Normally in situations like this, what the U.S. consulate does is they have a procedure where you are supposed to contact the U.S. consulate and schedule an appointment.
Okay.
And then go in and explain to them why you can't come to the United States within the time frame of the validity of the visa. Right. And they would issue a new visa to renew and extend your visa so that you have enough time to come to the United States.
That's the consulate in these times, or is there a form that they can fill out?
It's not a form or anything like that. Again, normally speaking, what you do is actually you fill out the DS, like you would schedule any visa appointment, you go fill out the DS 160, 260, and then you show up and then you explain to the consular officer to get the visa stamped. Now, right now, no consulates are open. Unfortunately, they're all closed. Right. So what you should try to do is try to write an email to the U.S. consulate. There should be the email still available to the applicant, mainly perhaps during the process of immigrant visa application process. You probably would have communication with the consulate or your local, whether it be Mumbai or Chennai or New Delhi. And you're supposed to get in touch with them, ask them the actual question of, hey, listen, I need, this is what happened to my family. We're stuck here. We can't come to the United States right away because travel restrictions, or because I have family matters I need to wrap up here, or I need to, need more time to quit my job.
Right, the pandemic isn't enough reason for us to make our case. So I would say Satish, right? He writes a letter to the consulate and requests for an extension. Is that what I'm hearing?
Yes, that's correct. Thank you for that. Yeah, provide a good reason, and usually the consulate would at least give you instructions on what to do next.
Very good. Thank you, Clement.
I just wanted to add that, I'm guessing some kind of, this does affect a lot of individuals. And so my guess is hopefully there should be some guidance coming out that will be a procedural type of, how to go about getting the extension for individuals who have been impacted, by this.
Cool, sounds good. We'll move on to the next question here. It's from Ashwini Sheetal. You mentioned about the amendment. So she wants to know, when do we apply for the amendment for work from home employees? Do we need all the documents like client letter?
Yes, so the amendment has to be actually filed prior to the change, whether it's a change in location or a change in hours. Any material change in employment requires an amendment. So that amendment must be filed before, like I said, before the change in location or the change in hours. The process is very similar to how the original H-1B was filed. So, all of the same documents would be required, including, contract showing work availability, for the period of time requested, information about the job duties, the individual's credentials, all of those, same documents would be required.
Okay, sounds good. We'll move on to Ronak Shah. Pardon me if I don't say this correctly. I'm trying to present the situation to you. if a perm is filed for someone via both employer-based, which is an EB2, and family-based F4 category, is there a possibility of any issues when the individual goes for H-1B visa stamping back home? Does the individual face tough questions from the consulate, such as why your green card is filed in 2 categories? Can his or her H-1B stamping face trouble in front of the consulate officer?
So no, H-1B is a dual intent visa. So an individual, can have a green card filed, but can also have green card filed in multiple categories, including employment and family-based, at the same time, no issues. As long as they fully disclose that when asked, but other than that, no issues.
Okay, and a quick response to people asking how they can ask the questions. You have a chat box in the bottom line of your Zoom. You can click on the chat and put your questions there. Make sure you put it to all panelists and attendees so that way we're able to read your question and be able to answer the question. We'll move on to another question coming from Salila Balakrishna. Would applying for re-entry permit jeopardize or delay my issuance of green card by USCIS when Form I-797 is issued?
That's an interesting question. Well, technically, a reentry permit is for permanent residents, green card holders. If perhaps Sayavila, if she's only mentioning I-797, perhaps she only has the approval, but not yet the actual green card in hand. I think maybe that's why she's asked that question. Just to clarify, a lot of times when USCIS approves a permanent resident petition, they don't send the green card right away. They will send a courtesy approval notice saying, congratulations, welcome to the United States of America.
Right.
We've approved your permanent residence card. Please expect a separate mailing containing your permanent resident card in the mail the next 30 to 60 days. That approval itself is not a legal document. It's just courtesy notice saying that, hey, you got approved. Okay. So you cannot use that document to apply for a reentry permit. Because technically you're not a permanent resident yet. You want to have the card in hand. Once you have that card in hand, again, it really should take about 30 to 60 days. Okay. Unless the approval notice mentions an extra item saying that, listen, before we can issue you the permanent resident card, you might have to go for another fingerprinting so that we can update our security checks. So that could be a possibility too. So I always tell our clients, please check your courtesy approval notices, read it carefully and see what it says, and then you'll know what actually happens next in terms of permanent resident card.
Yeah.
And that's really, I think that's what Salim is asking about. So because once you get the permanent resident card, you can apply for a reentry permit. The process itself takes maybe about 8-9 months, 10 months these days. But that's okay. Once you submit it, you're allowed to depart the United States, and then you don't need to have it at the time of departure, but you definitely need it when you return, right. Or you need to have the permanent resident card in hand to return to the United States, that's for sure.
Cool. We'll move on to the next question. We have a lot of these questions coming, and we will try our best to get to all your answers, all your questions here. Dhara Patel, I'm a green card holder. I've sponsored my spouse who is in India. He's already scheduled for interview, but due to pandemic, we got email that his interview is canceled and it's going to be rescheduled once it's open. Does 60 days ban affect me? Will the law extend because I'm a green card holder?
Yeah, so two different things happening, but one is, yes, the consulates are closed. And so if, the interview was scheduled, that of course would have to be rescheduled once the consulate reopens, and there will be some guidance on that, hopefully, like I said, coming up once the consulates do begin to open up. But this does affect many, many people who are in the same situation, including many of our clients. So, there definitely will be some guidance, forthcoming. With respect to the ban, the 60-day ban for immigrants that the Trump administration has put into place, that will be, the 60 days is June 23rd. And so we are going to be getting some new guidance, hopefully soon, as to, will it affect individuals in that situation. So, while the travel ban, the executive order is in place right now, a lot of it doesn't have that far-reaching effect because the consulates are closed anyway. However, we will, now once we get more information, really have an indication as to who will be affected, going forward after that date.
Okay, very nice. Thank you. The next question you have is from Patel. I applied for my wife's immigration in 2018. Currently in India, received email from National Visa Center mentioning document has been approved. NVC will work with the US Embassy Consulate in Mumbai to schedule an interview appointment. Will it take time for NVC to schedule an interview because of the pandemic? I'm assuming the consulates are closed right now, so it may take time.
Yes, correct.
Oh, yeah. Yeah, but there's going to be a lot of backlog, unfortunately. The way, U.S. consulates abroad, they do a first come, first serve. So whoever got canceled first usually will get rescheduled first. So there's going to be a lot of people in front of you in terms of they have to get rescheduled. And of course, every month there's available slots that are only limited. And with the way probably the consulates will have to practice social distancing now, it just means there will be even less interview slots per day because they don't want too many people at the consulate at the same time. So this could really sort of stretch things out for a lot of people, unfortunately. But it really will depend on what each individual consulate, how their policies go. And we're all very interested to see how they set up their timelines in terms of how they schedule these interviews moving forward, because certainly it impacts a lot of nationals abroad, for sure.
So another question, similar question from Raj Badeka. I don't know if you can answer this question, but he says, when will the US Embassy in Malaysia open?
My God, I wish I knew the answer to that. But hopefully, like I said, some more information should be coming up soon as the consulates, begin to open up.
Yeah, I think we're all
I think it
on that one.
Right. It really would depend on each country's conditions. Certain countries will be ready to open up earlier than others. So that's how they're going to coordinate them.
Okay, so we'll move on to a few more questions that we have here. Is there a hold on green cards and why?
So, I guess there is, in the sense of entering the US, there is the travel ban that we briefly discussed, but that's for certain people who, are entering the US, and that's that 60-day ban. It doesn't apply to everybody, but again, because of the fact that the consulates are closed, there's not, individuals coming in this method anyway. So you have, that aspect of it, but then you also have cases, individuals here in the US who are applying for a green card on a daily basis, and those applications are being processed by USCIS, even during the time, because a lot of time, people think that prior to June 4th, just because the USCIS was closed for the public, that they weren't processing cases, but they were processing cases, including green card cases. So green card cases are being processed in the US. It's just that final interview is not taking place. And now that the offices are opening up this week, slowly, the same way the consulates will begin doing this, slowly they will begin to schedule, those appointments.
Okay, very good. Are we still processing student OPTs and CPTs?
They're ongoing, just like Sheetal said. The USCIS is still processing employment authorization documents. It's taking them longer, unfortunately, because just because of the pandemic, extra safety precautions. And when it comes to CPT, the SEVIS and the ICE Yes, they're certainly still processing that, so you need to make sure, if you need to file it, you make sure you file it on time. Don't wait for anything or anything like that just because you think school's closed, whatever. The International Student Office is always going to be able to help international students, no matter what their closed or universities closed or not. They're open. They really are open for the summer session as well. So just make sure you, especially for F1 students, make sure you keep in touch with your International Student Office and advisor in terms of any renewals, any status maintenance, things like that. That's the best way to make sure you keep in status while you're here in the United States.
Very good. And then I have any changes for F4 status while we're talking about all the statuses here?
F4, I'm assuming that the sibling category, brother, sister category.
Yeah, are there any changes right now from a processing perspective?
No, there's no changes. I mean, the cases are still being processed. It's just that we'll have to see again. This is one category that does fall within, the 60-day ban. So we'll have to see what happens, after that 60-day period is over, around June 23rd date.
Okay, we have another question here. My mother-in-law, she already has a visa, but her visa expires on June 10th. She cannot travel right now. I don't know what kind of visa that is. If you can just give us that info. What is the process of extension? She has immigrant visa.
Yeah, that's we briefly touched upon that before, whereby because consulates are closed right now, so it's going to be hard to get an appointment to go in to the consulate to ask them to extend immigrant visa validity. But like I said, first thing to do is to try to write an email to the U.S. consulate and ask them. They usually do respond. I mean, we've written to them recently, and they responded, and they usually give us instructions saying that right now the consulate's closed, so we don't have any specific for you. But once it's reopened, please contact us again. Unfortunately, that does mean that the visa will be expired by the time everything happens. But don't still go ahead and contact the U.S. consulate and ask them for guidance and instructions, because you don't want to just leave it as is, because your mother-in-law is not going to be able to come with an expired visa, and you certainly want to try to help her to extend it. It does not mean you have to go through the whole process again like that, but you do need to get in touch with the consulate and let the consulate tell you and guide you as to the next steps there.
Yeah, I think the main question here for these kind of situations, I hear this a lot, is a panic in your heart, right?
Sure.
I sent an extension letter. Now my mother-in-law is here with an expired visa. Is that okay? How can I feel okay about that? That's, I think, the crux of the situation. So what I'm hearing, Clement, correct me if I'm wrong, but if you have sent out the extension request to the consulate, maybe you have some kind of confirmation that they received your application, but you didn't get the extension. Do you get a receipt, or how do you feel safe that we tried to get the extension?
Wow. Well, I think then in that situation, you're probably talking about somebody who's already here on probably a visitor visa status. And in that situation, that's a little different than contacting the consulate. Yeah, for any visitors here in the United States, your main source of contact is going to be the USCIS.
Right.
And yes, you definitely need to file any extension of status petition using the form I-539. You file it with the USCIS preferably before, your relative's underlying status, which is indicated on the I-94 arrival record. Make sure you file the extension before it expires, and then you wait. Our office usually use express mail or any way to track the package so that you make sure that the package arrives at the USCIS.
And
because
that even for India, like international as well, you have the receipt that you sent something to the consulate, so hold on to it. And I'm sure they understand, right? Everybody's going through these situations here.
Oh, that's true. That's
Yeah.
true. Yeah, again, obviously we tell our clients to make sure that you don't wait until the last minute to do it.
Yeah.
And a lot of times you file the petition so as to preserve your status here.
Yeah.
But be mindful that eventually the travel restrictions will lift, and it is entirely possible that the petition that was filed with the USCIS is still going to be being processed, and you might not hear the result for another 5-6 months.
Yeah.
But that's okay. All you need to know is that you filed it on time. It's there, sitting at some officer's desk. And when the time comes for you to leave the United States, you can leave. It's quite all right.
Yeah. I was just going to add on that note, for example, if somebody is requesting 90-day, B2 extension due to the travel restrictions, and that 90-day comes up and they're still not able to get back home, then file another petition because you want to make sure that any time that you are requesting in the US that you have submitted a petition requesting for that time, because you probably won't, you may not get a final decision on that first B2 application in that 90, 60 days that 60 or 90 days that you requested. So it's just important to make sure that they continue to do that. And it might sometimes require an additional, filing.
Interesting. Interesting question from Shalin Shah. Can a part-time H-1B employee apply for a green card?
Yes. So the person can apply for a green card in terms of, I'm assuming he's referring to employment-based visa, employment-based green card, and the individual can apply. However, the employer, and this is the important part, the employer must have intention to hire that person, that employee, on a full-time basis, on a full-time and permanent basis. So although that individual may be in part-time H-1B status right now, the employer, in order to file the green card and to begin the green card, they have to be willing to offer that person ultimately, permanent and full-time employment.
And it was confirmed that it's employment-based question.
Okay. Yes.
Cool. That's good. We have, I think we have another question. Can you please inform, this is from Satish, can you please inform if USCIS is reopening on 4 June? I think we spoke to that already. When is USA Visa Consulate in Mumbai again? I think we've spoken to that. Until I guess, it opens, we don't really know. I have received email from ustraveldocs.com that I will have to pay the visa fees again for renewal and go directly between 10 a.m. and 10:30 p.m. Wow, they're going to work.
Wow, that's interesting. But yeah, if that's what US Travel Docs is telling you to do, then unfortunately, you're gonna have to pay again. This is again, I'm not sure if this is across the world, but it's entirely possible that the consulate in question might have that particular policy because this is certainly new to everybody. So it's possible some consulates might not require you to pay the full fees again, or may require you just to pay part of the fees. But it's certainly important to reach out to the U.S. consulate where the initial immigrant visa was issued and ask them specifically what the procedure is, and follow that procedure and then go from there. And unfortunately, if it means that they ask you to pay all the fees again, then I'm afraid that that's going to have to be. And certainly, hopefully the new visa will allow for proper transition so that the relative can come to the United States during the time frame that the new visa is issued for.
Okay. I had one question for you from an H-1B restriction that I've been hearing. There's a talk about 250,000 proposed cap for H-1B. And can you share if this is going to pan out, when is this going to happen, and what does that help, making us understand what does that mean, especially for small companies, having a cap on a number like 250,000 on an H-1B?
Are you referring to the 250,000 salary?
Yes.
Okay. Yes. So yeah, this has been, I guess, in the news, and this has been reported that there may be, you know, a proclamation or something coming from the administration where they are trying to indicate that for positions, you know, very high level of wage would be required by employers, particularly for scientists, particularly for engineers. And so, yeah, this is definitely, you know, very problematic for, I guess, you know, the smaller companies, and I think just all around problematic, but,
Right. Yeah.
you know, we'll have to kind of wait and see. But yeah, that is what, that is one of the things that was mentioned, that they, you know, there's a possibility that this could be in the works, and we'll have to kind of
Still
see.
a possibility, though.
Yes, no, nothing official has been, you know,
Yeah.
provided, no additional guidance, but I would anticipate there will be a lot of opposition, you know, from employers. It's, you know, almost impossible for certain companies to hire somebody, you know, at a level 4 wage when they could be at a level 2 wage, and all the other employees are, you know, at a level 2 wage. So we'll kind of have to wait and see. And unfortunately, it does take a lot of companies wouldn't be able to bring in certain types of talent that they're used to if they're obviously not able to afford. And also there was mention, I believe, that this was going to be applicable for all levels. So, you know, it would be applicable for an entry level individual versus somebody who had, you know, 20, 30 years of experience. And so that's also, you know, the companies are not likely, especially for an entry level position, that's going to be very difficult. So they're, you know, in essence, I think the worry is that it's going to push the, you know, the truly talented, you know, out, and rather than offering them any kind of, you know, protection.
Interesting. Yeah, that's definitely something I'm following, and I'm trying to see what happens with it. And then, of course, we have one more question coming here. Um, I was on CPT before, and my H-1B was approved. I left my CPT halfway. Will it be necessary for me to complete the education while I was on CPT?
It depends on how the H1 was approved. The H1 could be approved with consulate processing, or it could be approved with change of status approval. Meaning CPT is somebody who's on F1 student status and they happen to be working while they go to school. So that might not be a choice, whether it might have been a decision made by the USCIS for this person. So what you need to do is you need to look at your I-797 approval notice and see whether an I-94 card is attached to the bottom of it. If there is, that means USCIS approved your change of status petition and you are on H-1B right now. Now, if it does not have an I-94 attached to it, unfortunately, that means that you're not on H-1B yet. You're still on your F1 student status, and you won't become an H-1B worker until you leave the United States, apply for H-1B visa, and then come back as an H-1B visa holder. So that's something you want to look at your approval notice just to make sure what it says. But to be clear, though, H-1B workers can go to school. There are a lot of H-1B workers who, you know, take classes at the same time. There's no prohibition against that.
Okay, sounds good. Any visas that have been, any visa services that have been suspended at this point? Looks like everything's working, but delayed is what I'm hearing from you.
Yeah, I mean, no, the non-immigrant visas, is that what you're referring to?
Non-immigrant visas.
Yeah, no, they, you know, at least here in the US, they're being processed. It's just, there may be certain delays and then, you know, those types of things that are happening, but they are processing.
We're coming to the end. If the attendees have questions, please ask now. I have one last question. And this is for Trump administration recently imposed new restrictions on Chinese journalists working in the US. I'm going to ask Clement to please shed some light on that.
Yeah, so fortunately, well, it's an I visa. That's what the media representative journalist visa is for. Normally, I visas are issued on duration status visas, status, meaning for however long you need to be in the United States to complete your assignment here, that's how long the visa is good for.
Right.
And that's always been the case for journalists for any country, really. But unfortunately, for Chinese journalists, what the Department of State has announced in May is that they're capping the validity of their I-visa duration from duration of status to 90 days maximum.
Okay.
So that means that you can only be here for 90 days at a time. And if you need more time, you're going to need to file for an extension of status and stay. And you're going to need to keep filing that until you get approval. Because unfortunately, these petitions will take time to process. It's not going to be a 3-4 month processing time. So what Sheetal was saying before about maintaining status for P2, if you need to extend more time to stay here, keep your stuff in status, you're going to have to do the same thing too for the I-visa status. Again, this is only for Chinese journalists. And unfortunately, this is because of the diplomatic tensions between China and the United States right now that it's come to this.
Okay. The last question that we have here coming from Dara again. Will Trump administration extend the 60 days ban, immigration ban after 23rd June? I'm waiting since 2.5 years for my spouse.
And I think I believe she's the spouse,
Yes,
the green card holder.
Yeah.
Unfortunately, Dara, we just have to wait and see what comes around. We're a couple of weeks away at this point, and we'll get more guidance. Really, I don't know what else to really offer at this point. Hopefully, it's positive, and spouses and families can be reunited once consulates are open. Yeah.
Good luck, and we're hoping for good news for you and your spouse, Dara. We have one more, Satish saying, I'm very grateful and obliged for the seminar meeting, and it has relieved me from being tense for now being able to get my family here in US due to visa expiry, and has made my concept a little clear for extension. That is really something I was going to say, heartfelt. Like when we began this conversation, there's a lot of uncertainty, and in that uncertainty there's a lot of scare, there's a fear, because immigration is such a topic that not all of us can speak like you both do. You guys can probably answer questions in your sleep, and we had a list of questions. Some of the acronyms I couldn't even understand what I was asking you, to be frank, but you guys were like on top of it with the answers. So through my heart, I'm going to say thank you so much. You guys really helped clarify a lot of questions. We're looking forward to having some more conversations with you guys on the Immigration Talk series, but really thank you, Sheetal and Clement, for taking the time today from your family to be here with us and answer the questions for all of us. Actually, you guys answered all the questions we had for you, so thank you so much.
Oh, good. Thank you, Usha.
Thank you.
Thanks, Usha, for having us.
Yes, take care. Bye-bye.
Bye. Take care, everybody.
Thank you to all the attendees for taking the time, staying on, asking the questions, and making sure we hope that we answered your questions. So this is Usha signing off from IndusTV. So thank you, Vijay Gar, for giving us an opportunity for having this panel and help answer some questions. Thank you. Have a good night. Stay safe and stay healthy, everybody. Thanks.